Now, the Centre for Applied Legal Studies have welcomed the recent North Gauteng High Court judgment upholding an appeal brought by the National Credit Regulator against Joshua Doore Group in a decision of the National Consumer Tribunal. Now, the issue was deliberated, concerned whether the selling of bundled insurance to beneficiaries of older persons' grants or disability grants is reasonable within the meaning of the National Credit Act, where such beneficiaries derived no benefit from such insurance, nor can they claim from it. Attorney at the Centre for Applied Legal Studies, Anesu Dera, joins us for more. Anesu, a very good evening to you. Thank you so much for your time. Social grant beneficiaries offered bundled insurance product have been protected now by the High Court. Was this the expected outcome?
Thank you so much. I think the outcome is really remarkable and big. Number one, because it's not only really going to help the concerned victims, right, implicated in the Joshua Doore case, but it's going to help all people in South Africa generally receiving old age grant and disability grant, in the sense that the judgment that meant that everyone really who receive old age grants and also have been receiving disability grants now can be protected by the law, in the sense that credit really companies like Joshua Doore or any other company really that offers credit to customers are not now allowed by law really to be offering policies that are beyond really the scope, or that are beyond what those concerned really victims could benefit from. So I think this is a remarkable judgment for everyone in South Africa.
I know that for years you and your partners have raised concerns about the lending practices of furniture retailers and micro lenders, particularly when it comes to their targeting of vulnerable individuals with little to no legal recourse. What formed the basis of your legal argument as you made this assertion and really tried to find a way to stop what was happening?
So what made the basis of our assertion, right, as you might have seen, right, from our papers, cows representing Black Sash came in as friends of the court, right? And our argument was mainly around section, right, 27 of the Constitution, which in summary, gives rise, right, entrenches the right to social security. So our argument really, or where we were coming from, is that the right to social security, right, comes in a positive form in the state of, in the form of the state having an obligation to provide social security. But also the negative element there applies to private entities, right? Like Joshua Doore. What does that mean? It means that private entities are also refrained from tampering around the right to social security. So then our argument was that if you are going to charge someone, right, who is already disabled, and you are going to force that person to pay for an insurance or a policy that covers him from disability, that policy doesn't make sense. You are ripping them off, right? So our expert, right, through the Harris report, came in and said that, if someone is already retired or retrenched, it doesn't make sense for that person to pay insurance against retirement or retrenchment, because that event is an impossibility. And according to insurance laws, really, you are supposed to pay for something that is that has a probability of happening. So what that meant is that Joshua Doore in this instance was benefiting in the sense that it was making receivers of social grants to pay for insurance towards events that were never going to happen at all. So it was making disabled people to pay insurance, against disability, which really didn't make sense. So then what we came in there was to argue that forcing or making them to pay really, such kind of policies is an infringement of their right to social security in the Constitution. Why? Because they are already receiving really a little amount in the form of grants that they are receiving, and then making them to pay for insurance under duress. Because under duress, it doesn't make sense. So now you remember that Joshua Doore was arguing that no, these people enter into these contracts voluntarily. But then that is not the case, because in practice, what would happen is that, let's say you go and you buy couches, right? Now, when you are at the till, after you've already signed for a credit agreement, right, to repay in small amounts the couch that you've paid, now at the till point, they say, wait, before you take delivery of this couch, you need to have an insurance policy that covers that covers your credit for this item that you have bought. So it is at that point whereby someone has already set up their mind to say that I'm going to own this property. Now, at that point, the court also, as it agreed with us, it's difficult for you to then reverse, a decision, or for you to go through contracts, reading all the fine prints. So now that act was then regarded by the court to say that no, it's in as much as they sign, but it's unconstitutional in the sense that the circumstances in which these vulnerable groups are signing these contracts really are not fair and are unjustified. Then number two, as I have said, that you are paying for an insurance for an event that is never going to happen at all. To put it in layman's terms, it's like, let's say, in a car insurance company making you to pay towards a car insurance, yet you don't own a vehicle. So they will always benefit because you don't have a car. So if I don't have a car, why should I pay monthly premiums towards a car insurance? So this is what was happening in these instances, whereby someone who is already disabled is insuring himself or herself against a disability. So what that means is that I'm paying insurance to say, if one day I am going to become disabled, then I have this insurance cover.
Mr. Dera, let me thank you for your time. Unfortunately, I'm going to have to cut you off there, but we get the gist of the argument there. Thank you so much for your time and speaking to us this evening. That was attorney at the Center for Applied Legal Studies, Anesu Dera.